On November 3, 1992, in Piscataway, Scott Johnson kidnapped Gail Scholler and her 3-year-old daughter. The crime began as a random carjacking. Johnson drove off with them in the victim's own car. Shortly thereafter, he abandoned the child in the dark of night at a closed daycare center. He next drove Miss Scholler to an isolated area behind a lumberyard where he sexually assaulted her and then savagely murdered her. Following this, he attempted to hide her body under several inches of water in a drainage ditch. An autopsy revealed that Gail Scholler had been stabbed over 40 times, including a slash wound on her throat. Early the following morning, her 3-year-old daughter was found alive, terrified, but otherwise physically unharmed near the daycare center. The horrific details of this crime stunned the Middlesex County community. The murder had all the elements of a suburban nightmare. A young, innocent mother and her daughter out on a family shopping errand are suddenly carjacked at random by a marauding criminal. The story remained front-page news for weeks. Following an intensive investigation, the defendant was indicted for murder, kidnapping, sexual assault, and related crimes. Apart from the sheer savagery of the crime, the facts and circumstances surrounding the offense provided the legal basis for the Middlesex County prosecutor to seek the death penalty under the New Jersey law in effect at that time. The one thing that all the attorneys involved in this case agreed upon is that given its monstrous facts, this particular prosecution would have been handled as a death penalty case by the prosecutors in any one of New Jersey's 21 counties. So the stage was set. Both the prosecution and defense were confronted with a high-profile case with a defendant on trial for his life. The following continuing legal education program will explore the complex tactics and strategies the prosecutor and defense attorneys in this case used to try the capital murder case of State of New Jersey versus Scott Johnson. Now, Part 2, the case for the defense.
Bob, how was it that you first became involved in the Scott Johnson murder case?
A friend of mine, Andy Harkove, was a private attorney in both Middlesex County and Monmouth County at multiple offices, and he had been asked by the Public Defender's Office to take on the representation of Scott Johnson about 6 months after the indictment.
Why you?
I had worked with Andy. Actually, I had brought Andy into some of his early death penalty cases, and we were friends and we knew each other and we had worked together before, and I had a lot more experience in death penalty cases than he did.
It seemed to me that in that era it was kind of the public policy of our Supreme Court to have a cadre of attorneys who were extremely experienced and skillful in doing death penalty litigation, both in terms of the trial level work as well as the appellate side of it before the Supreme Court. It seemed to me that the last thing the Supreme Court wanted was the town drunk or just some really insignificant attorney taking on the responsibility of a death penalty defense. And I take it you were one of that a member of that cadre of attorneys. Is that true?
Yes. Early on, Supreme Court makeup was obviously changes as the years go on.
Sure.
Back then, early on with capital litigation when it came into play, I thought the Supreme Court was very cognizant to be careful, as you just said. But so was the Public Defender's Office early on. Done about, I think capital litigation was instituted in 1982. I think the first case went to trial around 83. And the Public Defender's Office tried to train people. The Supreme Court had an independent list. And it was pretty short on people who would do capital litigation.
How many cases had you done before the Scott Johnson case?
I'm thinking.
That's okay.
I did the third or fourth or fifth. I did Zola, Lewis, Blackman, Brown, and there was 2 or 3 other ones involved. Oh, there was one up in Belvedere, New Jersey, Bobby Lee Brown. Mm-hmm. And there was an interesting case, Marcus Kojab in Monmouth, which is what the first case that Andy Harkov and I had really got involved with together. Not all of them went to trial. A couple of them pled out or disappeared.
Now,
and there may have been some others.
But there's no doubt that at this stage in your career as an attorney, you brought a lot to the table in terms of practical experience, in terms of defending people who were in capital cases. You agree?
Oh, absolutely. I think I had a wealth of experience. Plus, it was one of the things, because Scott Johnson was about 10 or 11 years after capital litigation came into play in New Jersey. It was a passion of mine to know everything that I could know about capital litigation and how to defend somebody on a death penalty.
Well, let me ask you about that. What was your reaction personally to seeing the jury come back and condemn your client?
The first time it happened, it was terrible. I remember the day, I remember the location, and I remember the case.
All right. And it stayed with you for a long time?
It actually stayed with me until the Supreme Court subsequently granted a new trial.
Did it put you in a situation where you say, listen, I don't want to do this anymore, it's too stressful, it's too devastating when I lose, and I don't want the responsibility for another human being's life?
I think any lawyer who really, really cares will think about that all the time. Mm-hmm. But I always remember something that a lawyer from the Southern Poverty Law Center taught me, is that if you don't do it, who is going to do it? And you have to have people who really feel that way to understand, not just go through the motions. Did
you ever have any type of social stigma among your peers or neighbors, friends, family members for representing really vicious murderers over and over again?
I'm smiling, but I've had the misfortune, or the good fortune, I should say, of representing a lot of vicious murderers on non-death penalty cases. Right. Now, I never really had that because, Bob, if you're going to do this business, you better have a thick skin.
Right.
Real thick skin.
I've always felt that the three characteristics you have to look forward to as a defense attorney is uncertainty, stress, and ingratitude.
And not much of any. But what I've often felt bad about is other people that were close to me that may have got questions about what I did. And ironically, I know we're here about the Scott Johnson case, but Scott Johnson was tried in New Brunswick,
right,
which happened to be the corporate headquarters of Johnson & Johnson, and everybody followed the case. My wife was vice president at corporate headquarters in Johnson & Johnson, and her last name is not Smith, so it was easy to put it together. She got a lot of questions. Nobody said anything wrong.